that this is a case where no steps are taken by an organ of state. The submission that we make is the following, is that the position may arguably be different if a municipality comes to court and indicates that in relation to what we have identified to be a problem, and if I may emphasize that the very problem that you've put to me with respect, Justice Matopo, is one that Councillor Heron, for example, made the statement that the city needs to militate against this. It needs to take steps to prevent or to address the consequences of people being displaced from their homes. So if the position was that the city takes either no steps whatsoever to do that, then it would be in breach of its reasonableness obligations. But in this particular case, the effect, we say, of the exclusion is this, and the city makes this very clear. They made it clear in their answering affidavit in relation to the application to amend that the question of spatial segregation, which the city has repeatedly identified as something that needs to be addressed, the question of spatial segregation does not apply in relation, the approach of the city to spatial segregation does not apply to emergency housing. That, we submit, is the second level of the problem, is that would then have adopts an approach where the very category which Bromwell identifies to be the category that is most in need, and we accept that emergency housing is not the same thing as permanent housing, but it is the location of that is different. If the Pickwick occupiers, for example, were occupying brick houses instead of the structures that they were occupying, and they get given transitional housing or emergency housing in the inner city area, which is of a lesser standard than that, the difficulty in this case is that not only do the Bromwell residents or anybody similarly situated